Hello out there in Freeman land. I'd like to remind the viewers that I am not a lawyer, solicitor or attorney, and this is not legal advice. Today we are going to take a look at common law and what it means and where it comes from, and maybe put to bed some of the myths. Can we use it? Does it have any practical application and support in your country? I'm going to be using Black's Law Dictionary 4th edition, as distinguished from Roman law, the modern civil law, the canon law, and other systems. The common law is that body of law and jurisdiction which was originated, developed, and formulated, and is administrated in England and has obtained among most of the states and peoples of Anglo-Saxon stock, as distinguished from law created by enactment of the legislators. The common law comprises the body and those principles and rules of action relating to the government and to the security of persons and property, which derive their authority solely from the usages and customs of immemorial antiquity, or from the judgments and decrees of the courts recognizing, affirming, and enforcing such usages and customs, and in this sense particularly the ancient unwritten law of England. Notice it says unwritten law of England. That is important. As distinguished from equity law, it is a body of rules and principles, written and unwritten. Again, unwritten, it's quite important, which are of fixed and immutable authority, and which must be applied to controversies rigorously and in their entirety, and cannot be modified to suit the peculiarities of a specific case or coloured by any judicial discretion. So further down here we'll see maybe designated all that part of the positive law. Positive law is very important. Juridic theory and ancient custom of any state or nation. State or nation, the definitions of those are very important. I will go into those in another video. Which is of general and universal application, thus marking off special or local rules or customs. There it confirms that marking off special local rules and customs, local to yourself, things like a claim of right, for instance. So now we can draw some logical conclusions as to how common law is defined in a legal sense. So it's distinguished from all the other laws, Roman, canon, civil. It's found amongst the Anglo-Saxon people. That's the Commonwealth nations, Australia, New Zealand, Canada, and even America. It's distinguished from law created by enactment of legislators. So that's statutes, acts, bills, legislation, legislative instruments. These things are made by governments. I'll be making another video about statutes, and you can check out my website for more information. I'll leave links in the description below. We can also draw the conclusion that it comprises of a body of principles and rules relating to the government and security of person and property. It derives its authority solely from usages, using it, and customs of immemorial antiquity, or judgments or decrees of courts. I'll be, recognizing, affirming, and enforcing such usages and customs. So I'll be making another video about courts. You can check out my website for more information. I'll leave links in the description below. It also, we can summarize that it is the ancient unwritten law of England. It's unwritten because you haven't written it yet. This is where knowing your rights and where they come from is important. And unfortunately, most people don't know their rights or where they come from. If you live in a representative democracy like New Zealand, you would be doing a claim of right. So it's distinguished from equity law, and it cannot be modified to suit the peculiarities of a specific case or coloured by judicial discretion. Judges cannot make decisions. They can only oversee the proceedings. It's either a tribunal or a jury making the decision, and marks off special or local rules or customs, things like the claim of right. So it might be worth touching here on case law. Some and most in the law society will claim that common law is just case law, and this is partly true. Case law is common law to lawyers because case law is the common law of the legal society's immemorial usage, and it always has been. The reality is, in the system we are now in, the lines between common law and the legal society statute or statute laws made by the government have been blurred. I'm going to make a video covering this in more depth. Check out my website for more information. There is a link in the description below. I should point out also here the dangers of statute law and playing in the legal society's field. Statutes can be a double-edged sword. Statute law, from my experience, always has a remedy, and it does support the free man or sovereignty ideology if you look and read. However, using statutes can indicate a level of understanding, and those of you who have been in the free man movement long enough will comprehend exactly what understanding means and how the system attempts to get jurisdiction either by coercion or deceit or by your ignorance. This is done in a number of ways. One is getting you to represent yourself in court. If you represent yourself, you are doing so in person, not as a man. The way to do this is to appear in propria persona, for oneself, from Latin, acting on one's own behalf. An example is challenging the jurisdiction of the court. You have to do it in propria persona, because if you had a lawyer represent you, by being represented, you would be consenting to the jurisdiction. I'm going to make a video covering this in more depth. Check out my website for more information. There is a link in the description below. Essentially, by understanding, you agree to stand under their authority and you surrender the inherent jurisdiction you possess as a man or woman. So I believe it's best to stay away from statutes and the system's rules as much as possible, unless they support your position. And in a lot of cases you can compare them to your own laws, like your claim of right. I'm planning to make a video about the claim of right. Check out my website for more information. I'll leave a link in the description below. So here, in the land of the long white cloud, we can find support for common law in the Imperial Laws Application Act, Section 5. Yeah, Application of Common Law of England. I'll leave a link to this here in the description below. And Section 5 reads as follows. In typical legalese doublespeak, they say it is part of the laws of New Zealand. Notice they don't say statutes. Yeah? They don't say statutes. And the name of the statute, the title here, is a big giveaway. Imperial Laws Application Act. Now, an act is a statute. Now, if statute and laws are the same thing, then why have they got them both here? Imperial Laws Application Laws? No, they're not the same thing. That's why they say statute. That's why they say laws, sorry. And you'll see here throughout this application of common law. And you'll also see it in the Magna Carta. So, yeah, for more information, check out our website. There's a link in the description below.